stay out of that one.
Great. Welcome, everybody. It is November 13th, and it's a Monday, happily. And this is the State of Vermont's Legislative Committee on Judicial Rules. And today we have 16 different rules to review in different various stages of being promulgated and made effective. And most of them are in a stage of basically saying thank you to all the hard people who've worked so hard on these various committees, getting these rules in shape for us to review and to put into effect. So let's begin. Eric, do you want to join us at the table, or do you want to just be there commenting on the sidelines?
I'm right here. Thank you.
Okay.
Yeah, thanks for asking.
Because you're welcome to join us here if you'd like.
Thank you.
Why don't you? Anyway, you're welcome either way. But I'm going to get Judge Treadwell and Judge Morris. Why don't you two take it away on our first promulgated rule, which went into effect October 2nd, or is there something else I'm supposed to do?
It's ready for that.
Oh my God, I totally forgot. We have to approve the minutes, which were so well done. I would entertain a motion to approve the minutes as distributed from our June 19th meeting.
So moved.
You want to second that?
I will second it.
Okay, great. All those in favor?
Aye.
Oh. All those opposed? Actually, do we have any discussion of those minutes before we go approving them so rapidly? I thought they were good.
They were very complete. Thank you.
Yes, Eric does a fabulous job. Eric, thank you. Thank you. Okay, all those in favor?
Aye.
Aye. All those opposed? Motion carries, and we have approved the minutes on June 19th. Thank you, everybody. Thank you, mostly Eric. So, John and Walter, the floor is yours.
Okay, thank you very much, Senator, and thank you, members of the committee. We are here. Judge Morris will, I'm certain, correct me if I get anything wrong with respect to the history regarding these two rules that you have before you from criminal rules. The first one is Rule 26, C and D, which was promulgated in July. It became effective October 2nd. It basically does two things. It changes somewhat the notice provision relating to disclosing evidence of other crimes, wrongs, or acts in criminal cases. It changes the disclosure requirement for the state and for the defendant with respect to disclosure of prior convictions to impeach a witness. This amendment is basically parallel to an amendment of the federal rules, though we have made the amendment in Vermont's criminal rules. The federal rules amended the rule of evidence basically because our criminal rules had the relevant notice provision in Rule 26 anyway.
Right.
The other part of the amendment to Rule 26 is updating outdated offensive language in 26D. There were, I believe, no comments received at any point regarding either proposed amendment, and they are and have been effective for a little over a month.
Right.
I don't know. Does the committee have any questions for us related to that amendment?
Questions? Everybody? Comments? We're beyond, I mean, we'd have to, as Eric reminds me, we'd have to have a pretty strong objection at this point, given that they went into effect on October 2nd.
Yeah.
Right.
I could add briefly,
Yeah.
you'll see in the rule that's been promulgated that there's this language of the permitted purpose for which the evidence is to be offered. The Rule 44B speaks to a laundry list of purposes for which it can be admitted, but it's not exclusive. And there's a lot of case law in this area interpreting what is or is not a permitted purpose. So it's important then, as the rule requires, that there be some advanced disclosure of the particular reason for which it's being offered, so that parties can fairly challenge that or litigate it or limit it or get the court to address any orders that are deemed necessary. Too much to say about, it's just a long way of saying it serves a good purpose and it's consistent with what the
Right.
federal law has already had for a number of years.
Right. And I appreciate that. I think if there are no comments, then our point at this moment is to say thank you for this work. And I guess my one question, given what you just said, Walter, is there absolute parity between what's required with the defense and the prosecutors in terms of disclosing these issues?
Glad you
The
asked.
things that come up?
Well, does it come up? It could come up if a defense is wishing to impeach a witness who is going to be testifying. That's pretty rare, though. It would come into play if you had a co-defendant, but it's unlikely to have co-defendants being tried together either. So it says the state or party, any party. And so it's intended to apply reciprocally or in the same. Yeah, good question.
So, well, no, it just, as I read it, it made me wonder whether there was that equity existed, because it is sort of focused on the prosecution.
Yeah,
Okay.
but it's to party, and that's
Right.
what we
Okay.
decide.
Thank you.
You're welcome.
So, if there's nothing else, I think we'll move to the second one, the second piece of your work together,
Sure.
17B and C and 45D.
Yes. Okay. So the amendments to Rules 47 and 45 basically relate to motion practice in the criminal court. The rule was promulgated. We received no comments. The rule was promulgated October 10th, and is effective January 1st. What it does is regularize practice across the counties. When motions are filed, the opposing party gets to file an opposition. And what this does is formalize the opportunity for the moving party, the party that filed the motion, to file a reply to the opposition. That was not previously allowed for or even addressed in the criminal rules, even though the civil rules relating to motions had been amended a number of years ago to allow for that. So this then basically makes this criminal rule parallel to the civil rule, and it eliminates a disparity from county to county as to whether the particular criminal judge would allow a party to file a reply memorandum without permission from the court. The other thing it does is it amends a provision in the rules relating to the filing of affidavits in support of motions. Previously, there was a deadline in the rule that allowed for affidavits to be filed 7 days before any hearing, no matter when the motion was filed, which was a little odd because often it made it hard to know whether you could rule on the motion without having a hearing if you didn't have the affidavit addressing the facts that were necessary. So what it's done is it's now requires that any affidavits be filed at the same time as the motion. Judge Morris, anything further on those two?
No, you've said it all well. Thank you.
So thank you. I would just remind us that this is an actionable item. So not all of the rules before us today are, but that and this is always such a great, I had this lovely tutorial with Eric about the rules, but that we have a 60-day window from the time it's promulgated or adopted, as it were, to when it goes into effect. So this is the period of time when we actually can affect things. If we have objections, this is the time to raise them. And so I'm curious about the committee's questions or concerns at this point. Dick, do you have any? Oh, we can't hear you.
We lost your sound again.
You're muted, Dick.
I was having a microphone issue, but we heard him when he came back.
We did hear him. Try unmuting. Can we hear you now? Oh, blood. Oh, your light is,
Signs.
yeah, we can hear you.
Now we can hear you.
Can you hear me now?
Yes, yeah, absolutely.
Okay, well,
Right.
that's interesting.
So any thoughts, Dick, on this?
I do not have any. I think it's just having a unified practice throughout the state, as Judge Treadwell mentioned, and I think it's probably a good idea.
I couldn't agree more fully. And I think the more we can get, sort of eliminate as many disparities between counties, the better. And so and I think that making it parallel to the criminal rules is terrific. Any other comments here?
That was good.
Okay. Thank you. Then I guess my one question is, are there additional aspects that the court sees enabling for more consistency between counties? Or is this one of your last efforts in that regard? Or are there other efforts you're making? Maybe this is a non-rule question, but are there other efforts being made to make more consistent rulings between counties?
Well, I can speak a little to that. There is a court-established committee on standard practices. And
Okay.
they periodically review things like practices among clerk's offices in processing of case documents, status of administrative orders that pertain to things like filing of exhibits in Odyssey, or as we call it, the electronic filing system. It's not just what are the forms looking like, because there are oversight committees that deal with that, but there is a standard practices committee of the court that's comprised of judges, clerk staff, administrative folks. So there's that effort. We also committee to committee communicate from time to time on things just like the Rule 47 changes that we've had. Civil Rules and Alan Kais will inquire of us as to what we think of this that they're going to do. And oftentimes we say, thanks for bringing that up. We'd like to do the same thing. So there's a good degree of informal communication about rules development and changes. And in so many settings, the issue of standardization of practice among our different units comes up. And you're right, Senator Clarkson, resources drives a lot too. So if we're talking about whether to authorize or enact a treatment court opportunity in a particular location, or early assessment screenings in certain units for substance or mental health issues, it becomes hard because the units don't have the same resources. Chittenden, Windsor are different from Bennington, and certainly Caledonia, the Kingdom, in terms of what they can offer. So there's consideration about that, but that's on an administrative basis. We'd love to have a treatment court in every unit, but we just don't have the expertise to comprise a team to run one right. So
yeah, I guess I have lots of questions on this, so I will save those for another moment and ask.
I do have a question.
So I think,
Oh, Dick has a question.
oh, Dick, yeah.
Yeah.
Yes, Dick.
Judge Morris, you just mentioned treatment courts.
Yeah.
And isn't that really up to the state's attorney?
They are.
To some extent, and I know that we had a very good domestic violence treatment court in Bennington County.
Right.
And Judge Sontag retired, unfortunately for the domestic violence court. And the state's attorney started refusing to send people to it. So I think I don't want to have that oversimplified, because
Mhm.
the local state's attorney has a lot to do with whether there's a treatment court or not.
Right.
Absolutely, you're correct, because of the structure of the court is such that certain, frankly, more favorable dispositions are granted to participants, successful participants in the case. It's the fundamental. And of course, the court can't tell what the state's attorney what to do with respect to a case. You're right.
Right.
So the buy-in of the state's attorney is absolutely critical. I guess my focus was more on the resource side and community-based mental health and substance abuse treatment, being able to effectively engage in treatment court. But you're absolutely right about whose authority is this. The court will not override the state's attorney if there's a reluctance to participate. So,
Right.
May I follow up on Dick's question, which is, so is a defendant, if there isn't a treatment court that serves the needs of a defendant, is a defendant able to either ask to be moved to another county that has that kind of court, or is a defendant able to weigh in here and ask for that being able to be considered in that court? Elsewhere?
short answer would be no. If the offense is in a certain unit, it's the state's attorney of that unit who decides whether to agree to a change of venue. And it's usually there has to be a particular reason for that. We have not had folks transfer knowingly from one place to another unit, say move from Caledonia to Barry in Washington for the purpose of enrolling in that treatment court. It's usually on approval of the state's attorney who has responsibility for the charges. So I guess the short answer would be no, although progress in treatment, which is a totally different subject than treatment court engagement, would be a factor in sentencing or in bargaining of the plea and disposition of the case. So,
Right.
yeah, my personal wish, which is irrelevant to the system, would be that we had that ability. But I understand exactly what Senator Sears is saying, is that the state's attorney is both responsible for and has authority for deciding what happens to cases committed within their county on behalf of the people of that county. So
I appreciate that, but they aren't in the financial position to create one without the support of the court.
exactly right. So
So
I would
we have
assume,
Walter, we have a real access to justice issue here. I mean, I assume that our committees are dealing with that.
Yes.
Yes, okay,
So,
great.
but just, I'm sorry to jump in, the
Go for it.
issue of venue is governed both by statute and rule.
right.
So in order to create flexibility to allow for changes of venue such as you are discussing, it would probably require action by both the rules committees and the legislature.
Got it.
Yep.
But to create, it sounds like the state's attorney could make the effort to create that treatment court in their county,
Absolutely.
but they'd have to then get the court to support that ask of the legislature
Well, if a state's
to
attorney,
finance it.
interesting question. But as far as the creation of one, if a state's attorney said, hey, we don't have a treatment court, Judge, will you work with us in setting one up? The answer would be, yeah, of course. Absolutely. It's seen as beneficial, uniformly beneficial.
No, I appreciate that. Okay, thank you. You've given, I know it's a little off topic, but actually an aspect of what we're discussing. So as we look.
Always.
Yeah, well, okay, well, thank you both very much. Any other comments? I think we're good to go on Rule 47 and 45. Thank you both very much for your work on this, and good to see you.
Yeah.
And I think we will now pivot to our third review of the day. Judge Jeffrey Kilgore, I understand we're going to miss Joanne, which always makes me sad, because it's always nice to see Joanne now that she doesn't live here anymore.
I believe she's at a daughter's swearing in this afternoon.
Oh, how exciting.
Yes.
Oh, well, that's great. So, may we move to our Rule 43, and we're going to shift to probate court.
Certainly,
Okay.
thank you.
Thank
Senator
you.
Clarkson and members of the committee. You have previously reviewed Rule 43.1. That is the rule that sets the rules for in-person, remote, and hybrid hearings. And the probate rule is a little bit different from the civil rule owing to the nature of the slightly more informal nature of probate proceedings. Our default rule is for remote hearings. And we also allow for both in-person and hybrid hearings. We're very generous in allowing hybrid hearings when it's necessary that folks appear if the nature of the hearing is more evidentiary, where it's important to see the demeanor of the witness.
Right, and again, this has already gone into effect on October 2nd, so if we have comments, they'd have to be pretty big for us to have any effect at the moment. So any comments on this? This makes sense to me, given the remote nature of many of the people coming before probate court.
I just have a question, and that is, and I'm trying to scan through this again because I read these a while ago. Can any party involved request that it be in person or hybrid? The default is remote, but I know
Yes.
that's not accessible for, okay, so that's all, that was my only question.
Yes, they may.
Any party that, yeah.
Yeah, I just want to make sure that it's not one side or the other is the only one that can make that change.
Any party to the proceeding can request either in person, although it can be slightly more difficult for everyone to be in person, especially if we have witnesses, as some of us have, that are out of country, out of state. We attempt to accommodate them, but if the nature is such that they need to be there in person, then we can do that, although we try to be as flexible as we can.
Perfect, yeah, absolutely. I just, like I said, I know that remote is not accessible for everyone, so I just want to make sure anyone can make the request, and you've answered my question, and so I feel good.
Very good, very good.
I want you to feel good in all things. So our next rule is about electronic filing, as I recall. This also went into effect October 2nd. And this is a pretty technical one, as I recall.
Yes, to some extent. The electronic filing rules were changed to reflect a little bit broader language, so that not just to reflect, I think it was the omission of the word statute. A statute can require that certain items be non-electronically filed. But I think the major genesis for the amendments to the electronic filing rules were because of the two changes in the probate rules, which are Rule 5E and new Rule 78. New Rule 78, we specified that to commence a probate proceeding, certain documents have to be original or authenticated, which means certified by a court. And so we don't initiate probate filings unless we have the original will, or if it's from an out-of-state proceeding, we have a court certifying that, yes, this is the original document that has been filed with this court. A similar situation when vital records are required. We have requirements for certified copies, or the organization creating those records to certify that they're duly authorized copies of that original. And those are governed by Rule 78.
and they're referred to again in Rule 5 to indicate that they have to be filed before the court can consider the proceeding. And then Rule 78 also contains language as to how those originals are disposed of. It's new in that at the conclusion or closure of a probate estate, as of October 3rd, we now return originals of wills. It used to be that we kept those documents forever. And now we are not. And it also provides a similar rule for the conclusion of a proceeding where we have vital records. We return those vital records to the folks that supplied them to the court.
Right, thank you. Dick, you have a question? And before Dick asks his question, Barbara, it's great to see you. Welcome.
Thank you.
Dick, yeah.
I'm just wondering about transcription fees, and can you describe a little bit about how much they are? Is it designed, custody transcription, is it designed to
Dick, I think that's the next rule.
Oh, I'm sorry.
No, that's okay. But I think that is the next piece of the probate question is, I think, is 47.
Okay, thank you. Well, keep that question in mind.
Is that right? Am I right?
No, I think you're right.
Yeah, I think the transcript fees is number 5.
Is number
I
5.
have a question about number 5.
Okay, so before we get to number 5, though, we're in this one, and I think this is, again, this has also gone into effect, and I think if we're all okay, we simply say thank you to Jeffrey and Joanne.
I'm perfectly fine with the rule, but it brings up another question for me and a sort of broader question that I have around the electronic filing system. I've heard a pretty significant amount of concern, both from employees using it and citizens trying to use it, that it is very difficult to navigate. And I wonder if there is any movement towards making a system that is easier for people to utilize.
Emily may have some thoughts.
I don't know the answer to that question, except that we've heard the same criticisms.
Yeah.
Yes, I've heard significant criticism.
Yeah, and in this committee, quite honestly, we have discussed this since the beginning of the launch of electronic filing in this committee, right, Emily? We've been discussing this.
Yeah, I mean, I'm happy to come up to the table, or if you want to save a question for later, I am on the agenda later.
Why don't we pick that up?
Okay.
Because it's been a big issue. They've worked really hard to improve things. I know it's still not fully improved, but I know it's made a huge, I hear
I
less.
would hope so, yeah.
Yeah. So can we?
Yeah, we can totally wait. It just, because we were talking about it, came into my mind, but I'm happy to wait.
Yeah. Okay, great. Let's make a note for that. So without objection, let's move the rule to number 5, which is the proposed rule that is, comments were due in September and it's not yet been promulgated. And so now is the time for comment on Rule 47. So Jeffrey, you want to present that to us? And as you already know, we have 2 people who have questions.
Certainly. Rule 47 was rewritten to be consistent with the other units in the manner in which transcripts are requested. The judiciary has a form where folks can apply for a transcription online to an approved judiciary vendor. And to Senator Sears' comment, I'm afraid I have no idea how much these transcripts cost.
We have Emily here who might be able to shed some light on that, or Eric. Emily, maybe?
There is a chart on the judiciary website that gives the pricing. It's the contract that the judiciary has. So I'm happy to give that website if you want to look at it in more detail.
Okay. Would you mind just emailing it to the committee?
Sure.
Great. So Dick, you'll get a link to the transcription fees,
Great, thank you.
which is on the website.
Do individuals do the transcription?
Are you asking Emily?
No, I was asking the judge.
Do you mean can
There's some
individuals
individual
initiate?
in the courtroom doing a transcription.
All the recordings are done electronically, and then those audio recordings are used to produce the transcript.
I see. Thank you.
So no court reporters sitting in the courtroom.
Okay.
And then before Tanya asks her question, Tom, welcome. It's good to have you. We are now complete.
Hello, everyone. Happy New Year.
Good to have you. Okay, Tanya, you had a question.
Yeah, my question is about whether or not there's a waiver process if someone cannot pay those fees.
Are you asking me?
I'm assuming you're the one with the answer to the question, but whoever has the answer, I'm happy to take the answer.
Yeah, there can be some proceedings where you could get a transcript provided without payment, but it would depend on what kind of a proceeding it is. So obviously, if you're eligible for public defender services and it's a criminal proceeding, you're not going to be paying for the fees of a transcript because that's a proceeding where there's some liberty interest that's at stake. That would be true for a juvenile proceeding or a mental health proceeding. If it's just a situation where there's no liberty interest at stake, so in a divorce or probably most probate proceedings, you're not going to be eligible for production of the transcript without payment, but there are a couple of rules that allow people who have financial circumstances to, instead of paying for a written transcript, either use the audio of the recording in lieu of a written transcript, so you wouldn't have to pay that cost, or to have those transcripts be produced pro bono. So our contract with the transcription service allows for a certain number of pages to be produced without payment. So you would have to make that motion to the court and explain why you would need those transcripts in your situation. So maybe in a landlord-tenant dispute or a custody dispute or something like that.
Thank you.
Jeffrey, do you have anything else you want to add before we?
No, I think that's it. Thank you.
Any other comments? How are we feeling?
Feeling good about this.
Okay, I think all things that help make things consistent with other courts is good, is useful. And Barbara, any thoughts? Yikes. I know you're full of thoughts, but okay, well, yeah.
Sorry, it's a different muting than I was used to. I'm okay with it.
Okay, great. Okay, I think everybody else is too. So I think without objection, we say thank you and it will proceed to promulgation, I guess.
Thank you very much. You're very welcome.
Well, thank you for your hard work. And if you talk to Joanne, tell her I hope whatever Camille's being sworn into went well.
I will do that. Thank you very much.
Okay, great. Thank you very much.
All right. Bye now.
Bye-bye. So let's shift to Scott Griffith, who I think is with us.
I don't think Scott is able to come.
Oh, is
I think
Scott
I'm gonna
not able to
cover
come?
this,
Emily,
yeah.
are you going to present this?
You want me here at the end or?
Yes, well, wherever you'd like to be. You could be wherever you'd like.
Feel very far away from all of you.
You can come closer. Listen, we're intimate group here.
Like a big table. For the record, Emily Wetherell, I'm the deputy clerk at the Supreme Court. And I know that Scott is also on the agenda. He had a family emergency and he's not going to be able to join us today.
Okay.
So I will cover I think the first item that's on the agenda there, 6, is that where we're at?
We are at number 6.
Okay, so these are a group of several rules, including a civil rule, a couple of family rules, and an administrative order. The committee did review these back at the meeting in June, and we had a long discussion. Scott was here for that discussion. He chairs the Special Advisory Committee on Remote Hearings, and I think he gave a little bit of background regarding that committee and the work of that committee. And we went over the rules in a lot of detail. So I'm happy to do that again, but I can sort of give you an overview, and then if the committee wants more discussion, let me know. If you'll recall, the kind of controlling rule is that Civil Rule 43.1, and just as Judge Kilgore was explaining regarding the probate rule, it sets a default of in-person hearings, but then allows for people to make motions to have either remote or hybrid, or for a judge in a particular situation to set a default of remote or hybrid. And I would say that in a lot of situations, these rules are really codifying a practice that developed during COVID and then continued to allow, really for more access to these kinds of hearings. I think during the discussion, there was a lot of discussion about the factors that a court should consider in deciding whether to allow for remote or for hybrid. And as I recall, I think, Senator, you had a
Marcy and Tanya both had questions here, so I was curious if you'd
Yeah, so one of them was regarding sort of the security of the parties.
Right.
I think Senator Mahowski brought up something regarding, in particular, if there was maybe a history there of domestic violence or other concerns that parties might have had regarding health and safety. So if you look on page 5 of that promulgated rule, so I'm looking at Civil Rule 43.1, and on page 5, it lists those factors.
You're jumping to the second one. Okay.
I am, and I'm sorry, the civil rule sort of is the controlling rule that is incorporated into the family rule, so it's an easier place to start if you'll.
Okay, so let's go, to 43.1. Okay, great.
And if you see on page 5 there, it provides that list of factors for the court to consider. And so if you see just there in the second factor, added in there was the health, safety, and convenience of the parties.
Right.
So hopefully in there that incorporates it. And then in the reporter's notes, there's a little bit more of a discussion of, how that health and safety consideration might play a part in the way that the court analyzes the parties' requests for either, being able to have a hybrid hearing where they would choose whether they want to come or not, or having a fully remote hearing. And then I think Representative Lalonde, you had asked about the disability of a party. And that's not particularly stated there in the list of factors. But if you look on page 15, which is the long the long reporter's note on on these factors, you'll see that there's the last sentence of that first sort of partial paragraph explains that there's a catch-all provision at the end allowing the court to consider any other relevant circumstance.
Right.
And this may include, for example, whether participants have mobility issues, a disability that requires an accommodation, or the need for a translator. So trying to provide a catch-all there for other circumstances that might arise that would weigh one way or the other in having an in-person hearing or allowing for fully remote or perhaps hybrid for some people to be remote and others to be in person. So I wanted to call attention to those two things that were different from what the committee had seen during that discussion. Other than that, I don't think that there are any major changes from what the committee had looked at back in June. This rule is now in effect. I think with things like this, no news is good news. So I haven't heard of any, issues with the promulgated rule here. 43.1 is a long rule, but as I said, I think that it has sort of simplified the process and put into place those procedures that had been sort of developed organically over the course of the pandemic.
That's great. Dick, you have a question.
I have a question and a comment.
Yeah.
I don't have a problem with video. I do have a problem with audio. I really don't understand how you can verify that person when it's, at least you can see somebody in a video conference like I'm doing right now. I'm on video. But I have never been comfortable, particularly family court proceedings. I would be very uncomfortable if a juvenile was being dealt with by somebody on audio. And maybe I'm missing something here, but I'm very uncomfortable with that.
Right. So
I think there's no problem with video. You can identify who you're speaking with.
Right.
You can see facial expressions, but you're talking about, divorce situations. You're talking about all kinds of cases in juvenile court, family court, I should say, juvenile delinquencies or family court proceedings. I see you struck all the language about video.
Right.
I mean about audio,
But
and I don't know. I've been in meetings where somebody's called in, and frankly, it's really difficult to deal with that. And I don't know how it would be if we're in a meeting that's hybrid and you've got some people in the courtroom and some people on audio. And how do you know who they are, by the way?
right. I have similar concerns, so maybe Emily can, I just think there's so much emotional nuance in it that is not captured if it's only audio. But Emily, what are your?
Yeah, thanks for the questions and for the comments. One thing I would just say at the beginning is that the way that the rule is set up, anything that's going to be an evidentiary hearing, so anytime that you're hearing testimony, live testimony from a witness, those all are going to default to in-person hearings. Someone would have to, there would have to be a finding of good cause to have those be remote in any way, whether that's video or just audio. So the court would have to do an assessment of those factors. And if you look at the factors on page 5, you'll see that what is now labeled factor 12, it says with regard to audio conferences, whether participation or testimony by video is not feasible or cannot be obtained without imposing substantial costs. So in other words, the preference is going to be for video. There would have to be a finding why they would only be able to use audio there. And number 13 there, if there's someone that just has audio, whether the audio connection and equipment is adequate to enable all participants to hear and speak at the appropriate times, and whether there's going to be a recording of that. And then if you look at factor 6 a little bit further up, there also is whether there's the assurance satisfactory to the court of the identity of any witness appearing by video or audio conference, whether the oath can be administered. And then number 7, whether there's going to be a full and effective examination. So in making that, if there is an evidentiary proceeding, if someone wants to do it just by audio, there's going to be a lot of things that they're going to have to show there before the court could grant that motion for audio only. And then if things are not going smoothly, and if the court decides that it's not going to be able to identify the person or hear the person or make that determination. If you look farther down on the bottom of page 7, there is a provision in there that allows the court to suspend or modify the proceeding or reschedule it if it finds that it really needs the personal appearance of somebody in the proceeding. So I think there's a lot of protections that are in there to ensure that, first of all, video is going to be preferred over audio if it will be remote. And then to make sure that if it is just going to be audio, that you can confirm who that person is, that everybody can hear the testimony. And if it's not adequate, that the court can have an in-person hearing instead.
So I would also add H9 as well, it seems, as far as.
Say it again.
H9 is one of the other factors that would seem to be relevant to that consideration of whether to allow audio.
Page 9.
No, H9 on page 5.
Oh, thank you.
Just throwing.
Yes.
Yeah, piling on.
Thank you.
Yeah.
Another of the factors, yes.
Right.
I remain uncomfortable with it, but I appreciate the explanation.
Yeah, I don't disagree. They're just going to need a judge and everybody involved to call the question on it sooner rather than later, I guess. Anybody else have comment, Randy?
Just a general question. In the case of individuals who are institutionalized or incarcerated, is there a typical practice or common practice vis-a-vis those types of people regarding remote as opposed to in person?
Thank you for that question. So most of the time, if you're talking about an incarcerated individual, it's probably going to be a criminal proceeding. So none of these rules that we're talking about right now would apply in those criminal proceedings, because in those proceedings, there's going to be constitutional rights that are, they might have a right to be present in the courtroom, they're going to have a right to confrontation. And so none of this paradigm is going to apply. If you're talking about say for example, a civil proceeding where there happens to be someone who's incarcerated that, they're in a divorce proceeding. One of the factors for the court to consider is whether that person is incarcerated or institutionalized. So that might affect whether that person is going to appear remotely or not.
Can a person, in other words, appear remotely involuntarily? For example.
Not in a criminal proceeding.
In a civil proceeding. For example, you may have an institution that says we don't have the staff to transport that person. And so therefore, we have to do it remotely against the person's will.
Yeah,
Is that possible?
It wouldn't be up for the institution to decide. That would be a motion to the court for the court to decide whether that person would appear in person. It does happen very frequently that those people that are incarcerated do appear remotely.
In other words, what I'm really getting at is, are we assured that that is a voluntary situation as opposed to the mechanics of their incarceration that dictates that they appear remotely?
That might be a better question for someone other than me, to be frank. I don't, I don't have a, yeah. Do you mean in not a criminal proceeding?
In not a criminal proceeding.
So can the court order that it's going to be remote?
Sure.
Right, so I mean, it may be a court order that requiring it to be remote, and presumably the institution has to accommodate that.
Well, that also leads me to the question about institutions. We have state institutions that we have a lot of easy control over, but we also have institutions that are private. And I'm just wondering, basically, do we have a process or procedure or set of rules or common procedures that deal with those kinds of situations?
I would want to make sure with the folks in the court administrator's office, but my experience, at least at the Supreme Court level, where we do have self-represented parties who are incarcerated, who represent themselves on appeal, the institutions are very accommodating, and I think at least everyone in Vermont now, they allow them to appear remotely. So the court doesn't transport them. These are not evidentiary hearings. They're just legal argument. The court doesn't transport them for those kinds of hearings.
Well, I think, for example, about the however many people we have institutionalized in Mississippi, transporting them for a in-person proceeding would represent some logistical difficulty. Does that ever happen?
I can add some information here that those folks in Mississippi are long-term.
Yeah, they're long-term prisoners. I realize that.
Very few.
They're not going to be a lot of court.
They're not in active court appearance.
Well, they could file the cases we see from individuals like that are if they're filing like a review of governmental action. So something about the conditions in the prison or that kind of thing. Sometimes they're involved in domestic proceedings like a divorce or something like that. But they wouldn't be required to be transported for those kinds of hearings.
Okay. Hey, Martin.
Yeah, it's a more general question. So is there going to be any, or can there be any tracking to understand how many cases are going to be hybrid versus remote versus in person, just to get an understanding how this rolls out?
It's a great question.
Yeah, I actually have one that tags along with it, which is are we doing any longitudinal studies to find out what's more effective and how is justice served remotely versus in person? I mean, which cases are settled? I mean, it would be very interesting to know who wins, who doesn't win, remote, in person.
And I'm also
just the quality
looking
of the case. It would just be great to do a longitudinal study on this, to track it and find out.
Yeah, it's hard because in the course of a case, you probably will have multiple hearings, and they might be conducted in different ways, right? You might have a status conference that's done remotely or hybrid. You might have a evidentiary hearing that's done in person. So you'd have to track them differently. And I'm happy to follow up in terms of statistics on numbers of hearings and if that is something that we can track. I'm not sure how we would track success rate of.
Well, it would just be interesting to see what the result of the case is, convicted, non-convicted, or whatever one would want.
Yeah, I don't know how we would, I'm not sure how we would.
Yeah, because it would be interesting long-term to know whether it's better to actually show up always in person or actually to do more things remote.
Yeah,
whether justice.
I'm happy to raise that with the remote hearing committee if that's something that I know this came up at the last meeting as well as trying to sort of get some data on that. I just don't know how you would assess success.
Maybe we could chat about that and
I have a follow-up question. Did you have a question?
And then Tanya has a question.
Yeah, go ahead, Mark.
So I guess I'm as concerned about efficiency as well. I mean, justice delivery, and are the courts using hybrid and remote in a manner that is making it more efficient in processing cases? And I'm kind of also curious if there are certain judges that always are required in person, and if there can be some training if remote is actually going to move dockets a little more quickly. So I want the results to be good, but I also want
it to be efficient.
Right. And if more remote hearings are going to move things along more quickly, I think that as long as it's not suffering the quality of the.
Yeah, I think that's one of my concerns, yeah.
Efficiency, yes, but I also want to balance like the justice aspects. Like I think about someone in Mississippi filing something around prison conditions and then the court saying, well, it's more efficient for you to be remote. That might be a problematic space to be in a prison where I'm saying the conditions are bad and I'm stuck here having to testify. So I want to figure out a way to suss out the balance between efficiency and the interest of justice. Like, yes, it's a logistical nightmare to transfer someone from Mississippi. Maybe we shouldn't have people in Mississippi, but that's a different conversation. But I also see instances where in the interest of justice, that would be the right thing to do.
Is that captured in, I guess, a question for Emily, is that kind of issue captured in the various factors for determining if there's good cause? A situation like this hypothetical.
I mean, I would hope that that's exactly what those factors and that good cause requirement is supposed to give the court an opportunity to assess, right? Is this a situation where we have this balance of we're trying to be efficient, we're trying to make sure that those people who, for coming into the courthouse, it's a hardship, it's a burden to have to come in, get childcare, get transportation, get time off work, versus is this a situation where there's going to be a difficulty in assessing credibility of witnesses, where there might be reasons that we need to see people in person, we need to have, and that, that is the best place for that determination to be is with the judge who is going to be assessing in that particular circumstance a variety of factors.
Okay.
So I have on here again the desire of this committee to get some more information. To the extent that that's available, and I will. I guess I should say too that the court administrator, she always likes to be at this meeting as well, and was unable to set a meeting that she was unable to reschedule, and so she is sorry to give her regrets for today as well. So
we always miss her.
I will follow up with her, and if there's more information that
it's not just the cookies.
It's not just the cookies.
Although the apple bread pudding,
or the cake,
I understand is
or the carrot
served in the Addison court this morning.
Yes.
If only we were there.
Right. Well, just in the interest of time, I think if we're okay with Emily getting back to us on some of those issues, that would be great. I think other than that, these rules went into effect October 2nd. Are we relatively sanguine at the moment?
Can I put one more
Yeah,
remote, this is not related to the rule in front of us, so we're putting remote issues on the table. Another is an issue I heard about family court, but you have, let's say someone, a father who's incarcerated, and they legally have access to remote court proceeding for family court, but what I've heard is that DOC, maybe it's DOC, they don't really prioritize that, so that the incarcerated person might not effectively have access to the remote proceeding from the facility. And it doesn't necessarily sound like it's a judiciary issue, but while we're putting issues on the table, remote participation, it came to mind. Do you have something you are aware of or can look at?
I don't personally, but I'm happy to see if if that's something that has been discussed in the Family Oversight Committee or that has come up, in the court administrator's office to get back.
Could I ask?
Yeah, Dick.
Could I ask that my objections to audio participation be entered into the minutes?
I think they already have been.
Yes.
Yes.
Yeah, thank you, Senator Sears, for reminding me, but I've got it down as well.
Thank you.
No, I think it's something to track. I mean, I think all of this sort of the digital introduction into these proceedings are great, and hopefully they make things more efficient. But I think there's a lot of emotional nuance lost in not being able to see someone react and respond. And Dick, I think it's something to track and be cautious of, but I guess I'm comfortable enough with what Emily has said in terms of the ability to pull it into in-person or to require video if the court decides it has.
I also want to be in agreement with those who have expressed concerns about inmates testifying. And not only is it difficult for the inmate in some cases to do it remotely, it's difficult for the staff because they have to put two people on that one person. And when you're shorthanded to begin with, it often becomes extremely difficult for them to get two people into the room to have it done remotely. So I think many good points were raised. But I'm particularly concerned about the audio in the family courts.
Thank you. Okay, I think we say thank you to Emily for these three. Thank you. And more to follow. I think now we're all very interested in the remote follow-up.
Yes.
So next meeting we will.
Thank you.
Or anything you have, feel free to share. I think share with us as a committee in between. I think all of us are pretty interested in this. And I think what I'd like to work on is figuring out the additional questions we'd love to look at is, and how do you get the quality of the cases, and I'm not a lawyer, so I don't know the exact questions we'd ask, but we'll figure them out. So thank you very much. I think we're going to shift to Judge Corbett and Jennifer and Professor Rushlow. Do we have them both with us? Yes, we do. Welcome. Yes, there you are. So you are on deck to work with us on number seven, which is the comments are due in December. So this is an active discussion for us, the amendments to various rules, which we have in front of us. And these are primarily, as I understand, technical gender, truing up gender reference in statute and in the rules of evidence,
That's right. So the Vermont Advisory Committee on the Rules of Evidence was unanimously concerned that in 2023, our published rules of evidence assumed that witnesses would be men, that experts would be men, that lawyers would be men, that the parties to court cases would be men, and that criminal defendants would be men. We're grateful to our member Karen McAndrew, who volunteered for the task of combing through the rules of evidence to find and eliminate those references. She succeeded in removing pronouns entirely from the rules of evidence and replaced them with as needed with nouns like the witness, the expert, the person, the party, the lawyer, and the defendant. At times, sentences needed minor stylistic adjustments in order to accommodate a sentence that is written without pronouns, but no substantive changes to the rules were intended by any of the amendments.
Thank you. Much needed work. I'm surprised it's only happening now. Anyway, any comments, committee?
Thank you.
Great, thank you. And if we do have comments, the comments in December 11th, so feel free if they occur to you after this meeting, I guess let Emily know.
Comments go to Judge Corbett.
Comments go straight to Judge Corbett. Okay, great. Thank you. I think then we say thank you. There are no comments at the moment, but thank you very much. Good work.
Thank you.
Great. So we are going to speed ahead now to Emily again and to, you could have just stayed at the table, to our Administrative Order 11. So this is number 8, Administrative Order number 11.
Again, Emily Wetherell, Deputy Clerk at the Supreme Court. Administrative Order 11 is the court's process on public notice and comment on our rules. And there are a few changes that are, I think, a little bit more housekeeping. You can see if you're looking at the proposed rules there, you can see in section 2, the promulgated rule. There were a few rules committees that were not in Administrative Order 11 yet. So we've added the rules for environmental court proceedings and the rules for electronic filing, small claims procedure, and mandatory continuing legal education. So these are all the sets of rules that typically rules are sent out for public comment. And in the list of committees there, the Advisory Committee on the Rules for Electronic Filing, that's a fairly new permanent committee. And then the small change in section 5, which is on page 2. These are situations, usually the rules that are sent out for comment are sent within the judicial community. So they're sent to members of the bar, but also to clerks and coms. But sometimes there are changes that might affect members of the public more in general. And there is a process there for the court administrator to get a more generalized notice and comment out. And instead of just limiting it to publication in a newspaper, which a lot of people don't read the newspaper anymore, if you can believe that, it now says through reasonable means, including by inclusion in a newspaper. So the past few times when we've done this, it's through social media accounts, to get on our website, to get that information more readily out to members of the public.
It is a little frightening if you're reading them on the listserv. I mean, I'm sorry, anyway.
Yeah, so those ones that are out to members of the public, instead of listing all of the rules, those are rules that are sort of targeted to the public, where there might be, for example, those remote hearing rules that we were discussing. Those were more generally disseminated, not just to members of the bar, because they could they impact members of the public in general.
But for us, this actually impacts this committee in, I think, actually a fairly nice way, which is if the rule effective dates are going to be the first and on the first and the first of the 7th, then promulgation needs to happen on the 1st of May or the 1st of November, which will impact our meetings, which would be great because then our meetings could actually take place and be planned for moments when we actually could have effect on rules. Now, I mean, so that our comments actually could be effectively incorporated. So I am sort of a fan of this change, and I hope it makes your life easier, but it also helps us regularize, I think, our committee meetings, which will be, I think, effective.
So you got there before I was there.
Oh, sorry.
No, that's fine. That's great. The biggest change I would say is on page 3, which is that new section 9. This was instigated by members of the bar, and I think it was during COVID when some of you who were on this committee back then recall that there was a lot of rule changes happening on a very fast basis, and people were saying, I cannot keep track of when rules have changed, when those rules are going into effect. It's highly confusing. There were also some judges that were saying the same thing. It's really hard to know whether a rule has been changed. And so there was some pressure there to regularize. The initial suggestion was to have one time, just like most legislation becomes effective July 1st, to have one date that rules would become effective. And that was revised a little bit to say January 1st and July 1st. So this proposal went through all of the different rules committees. It was supported by civil, family, criminal, electronic filing, probate. So basically what the rule says, as Senator Clarkson explained, was that ordinarily rules will have an effective date of either January 1st or July 1st, so that people can keep track of knowing that. I think, Senator Clarkson, the only difference that I would say based on what you had explained is that the court might promulgate something more than 60 days before that. So the court could promulgate something, for example, at the end of January, but it would be effective July 1st. So it would have at least the 60 days.
Right.
They may not wait and consider all rules, 2 months before. They might, I think they'll continue to look at rules. And there might be situations where, as you can see in what is now Section 10, old Section 9, they might have to dispense with waiting if there's a reason why a rule might need to go into effect
earlier,
more quickly.
Right, no, I get that. Well, I think it will have a positive effect on everybody and help clarify things, so I think this is great. Any comments from the committee? Mark?
Just on the 60 days. So if something is promulgated at the end of January, will that period where we can comment extend to July 1st, or is it just going to be the 60 days that we would still want to get in and talk about that rule?
So the way Eric and I have tried to arrange the way that we've worked this out over the years is that usually we try to get a rule on your agenda when it's still in that proposed phase.
Right, which is ideal.
So it hasn't yet been promulgated.
Right. Yeah, okay.
So that if the committee has feedback, for example, with that 43.1, we had a discussion when it was in a proposed phase. There was some feedback that the committee received, and some of that feedback then you saw it materialize into the proposed rule, into the promulgated rule. Once it's promulgated, even though there's that 60 days, the process under the statute is, and Eric can probably better explain this, but it's an actual formal objection that the committee has to make. I don't recall that ever happening since I've.
It's happened once or
twice. Twice I can remember writing formal objection letters to the court.
So maybe before I was there, but
right.
It works definitely better if we can try to gain some feedback from the committee when the rules are still in that proposed phase.
Much more productive.
So we'll continue to try to.
Right.
So I would say don't necessarily wait until a rule is promulgated before you meet to.
So it doesn't necessarily help our schedule a lot.
That would be my only caveat as well.
Well, ideally it helps. Let's talk about it in the ideal.
But that's up to you.
Eric has a question.
I did have one other question.
Okay. Why don't you finish and then Eric?
So the language through reasonable means, including by inclusion in one or more newspapers, does that language mean that it must be published in a newspaper? Okay, I just wanted to clarify that's.
So the court felt like putting the notice in the newspaper is still a good idea, but that there should be other means that would also be pursued to put the overhead there.
Because ideally, people are still reading them, even if it's online.
What newspaper does the court use?
That's the paper of record.
I in the past, there's been like 5 newspapers that we've used, and it's around the state, so I don't remember the exact list, but.
Hearing that it's 5 is helpful.
Yeah, they're meant to be the different, sort of geographic regions of the state. Yeah.
Right. Eric.
Yes, thank you. Following up on Representative Lalonde's question, I think he was kind of asking more about the comment period, but I'm wondering about the objection period. So like the way it works now is that since there's always this 60-day window between the promulgation date and the effective date, then we always know that it's during that window that LCJR can object. So as you're saying, though, sometimes now they may promulgate in January, but it wouldn't go into effect until July 1st. So would that mean that the committee's objection period was longer than it is now?
Yes, that's my understanding. So for me, that still means that it means that I mean.
But again, I would encourage the committee to look at it when it's in the proposed phase.
Of course, absolutely, yes. Obviously, always want to look at it, comment period first, so that the committee can send the comments back to you.
Yeah.
But that would be the effect, I think. Just want to make sure we were right on that.
Yeah, I'd want to look at the statute one more time, Eric, before you can get me on the record.
Right.
I would want to look at the language of that objection language, which I don't have in front of me right now.
Right. That'd be great if we get on the same page.
Yeah.
Yep.
It would be very helpful for us to use this in a constructive way, but between our separate branches of government.
And certainly there are sometimes reasons why rules need to go, and that happens now, even sometimes the 60 days, you know, there are emergency rules because there are situations where.
We've lived through that.
Yes, we.
Okay.
I think that I'm not on the agenda anymore, so I'm.
You're not?
happy to wait till the end and address the e-filing question at the end so that other witnesses can do that if that makes the most sense.
Why don't you, if you're going to leave.
No, I'm going to stay here, and what I'm saying is I know I'm not on the agenda anymore, but
Right.
I'm happy to stay until the end to address
Okay,
it.
because we need to eat, and sadly, pretty promptly in about 5. So,
So if you want to get through the other witnesses, then I'd be happy to.
by the time we now discuss it, if you can briefly answer, Tanya, that would be great. Is that possible?
Sure, yeah.
Okay, great.
What I understood your question was, that you're hearing feedback about the electronic filing
Right.
system. So 2 things that I would say. One is that the court has set up a lot of mechanisms for people to provide feedback. There is a court users group, so that's specifically
Right.
a group for attorneys. For self-represented parties, they're not required to use the electronic filing system. So if they're having issues with the electronic filing system, they don't need to use it. They can email the court, they can come in person and hand things in, they can mail things to the court. So they have lots of ways that they can file things with the court that do not involve the electronic filing system. And then I would say that please make those specific objections, share whatever that information is with the court administrator's office, so that we can follow up on that, because I think that huge improvements have been made to the
Right.
electronic filing system, and we're continuing to work both with those external partners through the court users group and then internally through the change advisory board to try to work with Tyler, who's our contractor, to do what we can to address any.
We were pretty vociferous about it at the beginning. We were.
But I would concentrate on the positive changes.
Yes, and I think we have seen positive changes, although.
Does that answer your question?
It does. And I think it sounds like I might need to do some follow-up with the court administrator's office, because of that certainly very recent self-represented people are not getting the message that they don't have to use the electronic filing system. They're being told that is the only way to file.
Yeah, so I would, wherever they're hearing that from, or make sure you get that feedback in.
Yeah, that would be great. Okay, I think without any other comments, we're ready to move along, and we say thank you to Emily.
I'm here, so.
Well, thank you for all your work on this. And let's shift to Alan, and who is joining you? Professor, you're here alone. Oh, no, you're never alone. You have this whole committee with you.
In my attic office.
It's good to see you, Alan. Please introduce us to the changes made in Rule 2.
Yes, it's Alan Cos. I'm chair of the Advisory Committee on Civil Rules.
Right.
This is Small Claims Rule 2, and this was an emergency rule without any notice to the public or notice or 60 days for the legislature. What this does is conform the rule to the change in jurisdictional limits for small claims.
Yes. A big improvement, I think.
We we did send it out for public comment, or the court sent it out for public comment. When they promulgated it, the comment period is expired without any public comment. And the committee had a fresh look at it after that, after the summer. And unless there's any questions here, the committee's prepared to report back to the court that no revisions need to be made.
Right, and this, as I recall, moves the small claims court threshold from 5,000 to 10,000. Is that basically what this does?
Yeah, and then there's the 5,000 limit is retained for certain debt collection actions.
Okay. Any comments?
Looks good.
I think this is good. Dick, any comments? Barbara? All set? I think
No,
we're
just thank you for
good to
changing
go.
the rule to go with the law.
Yeah, right. I mean,
That's when the rules match the law.
yeah, it's it's conforming, which is good. We like things to be consistent. So you're also on deck, I think, for Rule 28 and 30?
Yep, this is.
Alan, do you want me to do this?
Say that again, Emily.
Did you want me to do this one?
Well, you can correct me. I'll try to just briefly summarize it.
Thanks, go.
And the court initiated this. They found that switching to electronic case files and reading briefs on their tablets and computers was fine, but the thousands of pages of records wasn't. And so the initial impression that we did not need a printed case was false. And what this rule does is reinstate the printed case requirement. That the contents, there's certain required contents, but basically the rule says the relevant parts of the record should be in the printed case. And the rest of the changes, which I guess that's Rule 30, that change in 28 tells the attorneys how to cite and when to cite the appeal volume or the printed case, and to make sure the appeal volume can be referenced from the printed case, from the contents of the printed case. So I might say this rule, among all the rest of the appellate rules, is kind of detailed, but all these rules, whether it's the page limit, the word volume, other technical requirements, are all there to make it easier for the court to decide the case. And the appellate rules really do provide guidelines for attorneys to make it best for the court to be able to read all these briefs and decide the cases. And this is one of those changes that was needed.
Right. So in my simplistic mind, we're sort of we're going back to the way it was?
Well,
in large measure?
We're having a printed case in most cases, where for the last 2 years, it was optional to have the printed case.
Right. Any comments? Because this is our moment for.
I'm a big fan of paper, so I like this.
What?
It's called a printed case, but it's actually electronic.
Oh.
It's not on paper.
That breaks my heart.
Actually makes me much happier. I'm a big fan of trees.
I'm a big fan of our forest products industry, which requires paper. Remember what side our bread is buttered on in our economic development act. It's very consistent. Any I'm fine with this. How does the rest of the committee feel? Okay, great. Okay, then we say thank you, and we move to number 11. I think, Alan, you're on deck for this, or you and Emily are on deck for Rule 64?
This is me again. This is a
big technical one.
A technical amendment, and it's already promulgated. There were this is a small corner of the rules on replevin that didn't get updated when the district court was abolished. And so there was some language in there that was confusing. It was called to our attention and made these technical changes.
I think deleting. deleting obsolete references is always useful.
Yes, this one referred to a district judge, and it also referred to the jurisdictional limit of the Superior Court, which had been amended a long time ago. It used to be $5,000 minimum for civil cases, debt collections.
Okay, committee members, any objections to deleting obsolete references? Okay. I think we're good, and we say thank you on this one as well. So
Okay, the next one.
Let's move to 4, 55, 62, and 80.
This is kind of intricate. It starts, I think, with Rule 55, and perhaps a small change in Rule 55. Under Rule 62, you could not serve execution on a default judgment until the default judgment itself had been served. We received a request to make service of the default judgment a general requirement, not just prior to execution. This was from Civil Oversight, and it was consistent with changes they had requested and had been made in small claims. And I think the motivation basically was the party who's been defaulted sometimes challenges the default judgment itself. If this comes late in the game, it complicates things when other procedures have already begun. So the idea was require service of the default judgment. We have received, this is out for comment. An earlier version was sent out for comment, and we did receive objections from the creditors bar, who basically said it was redundant and unnecessary. The summons says if you don't appear and answer, you're going to be defaulted without any further notice, they say. And so why should we serve twice? It's an extra expense that causes delay. And they said, and there's no way to recover the extra cost. This is post-judgment. We're going to have to go out and get another serve again. Shouldn't we be able to recover the cost? So we responded to that by adding Rule 80 into the mix. That's the default judgment provision in mortgage foreclosure, and in Rule 55, adding a similar provision that said you can in advance estimate the cost of service and include that in the judgment. But the committee felt we should go ahead and require service of the default judgment in cases where the defendant was defaulted for not appearing as a matter of course. That brought us to how is the service to be made. In Rule 62, there was a method of service that was a cross-reference to Rule 4 and then added a provision about publication. And when we looked at, we thought that was confusing, and indeed thought the method of service in Rule 4 was a little confusing. So we ended up, if you look in Rule 55, I think it's 55D, the method of service is a 4-step method. First, you try to serve under D and E, which is send out the sheriff, for example. If that fails, you attempt service by return receipt mail. And if you don't get, if you get the receipt, that's fine. If you don't get the receipt, then you follow up with an ordinary mail. That's the 3rd step. And so long as that mail is not returned undelivered, and you file return of service saying that you used the last known address, that is that service is complete. What we changed, that's very similar to what was Rule 62 and Rule 4 provided in combination, but what we changed was Rule 62 said it was an alternative to use personal service or mail. You could go directly to mail service, and the committee felt you should use due diligence to serve personally before going to mail service. And then the tail end procedures on the return receipt mail were changed a little bit by teasing it out exactly what happens if you get a receipt or don't get a receipt, and making sure that the address you use was a good address. The old Rule 4 said you either get a return receipt or a refusal, and that's not the only alternative. It could be just returned undelivered. So we clarified that if it's returned undelivered, it's not valid service.
Right.
That brings us back to Rule 4. The provision for mail service in Rule 4 was a limited form of it's the only provision for mail service labeled as such in Rule 4. And we changed the provisions in Rule 4 to conform to the changes that I've just described. And then we tinkered with the captions of the rule to take personal service out of the captions of the rule, and to clarify that the rule, the mail service under Rule 4 was only for service outside the state, which is not quite clear. And lastly, we moved as a kind of another housekeeping measure. There were different subdivisions of Rule 4 that related to service on the Attorney General, and we moved one to the other so that all service by mail on the Attorney General are in the same rule. And that's my summary.
Well, thank you for a rather technical group of amendments.
Yeah,
Thank you.
The main question is whether to go through the exercise at all, requiring service of default judgments as a matter of course, or only at the last minute before execution.
Right. Dick has a question for you.
Well, I have a question about the United States mail. It isn't very effective in many locations in Vermont, particularly Bennington and North Bennington. I've had weeks where we get 1 day's delivery. I've had times when I've gotten other people's mail, and I'm sure all of you around the state are suffering from this, and probably not just in Bennington. So to expect somebody to receive mail, they may not get it, and you may think they're ignoring your court order, but they may not get the mail. And I'm wondering if we could do it by UPS or FedEx or some other company that's more reliable than the United States Post Office.
I think it's different all over the state. I mean, we still have pretty good mail in my neck of the woods, and
well, you're lucky. Just wait.
Yeah, I realize.
If I wasn't clear, this rule prioritizes the use of other methods other than mail first. You have to first.
Right, you prioritize in person.
Right, and second, if you use mail and you don't get the receipt, then there's a second step of ordinary mail. If it's returned undelivered, the service is no good. But I'm understanding you to suggest that we include commercial FedEx or UPS within the definition of mail, and have their return receipt effective.
Saying that the mail that I surely get is delivered, there's something with the U.S. Postal Service. They have, even Sundays we get the mail, special mail. Usually for me, it's from some company like eBay, but I've just found our regular mail is just bad. I wouldn't necessarily get something from the court. And if you expect that mail to get to another state, they're having similar problems around the country. And I've talked to our congressional delegation about it, but I think we have to look differently on mail, and quite frankly, than we used to. I know we did away with requiring, certified letters and so forth, but because of the cost, but we may have to get back there.
Yes, the cost with any other delivery system, I think, would need to be reviewed. I think maybe, given that concern, we might ask the court to actually sort of track that and see what, I know the effort is to deliver these services in person first, but we could begin to keep our antenna up on challenges if there are some that are emerging with delivery by mail. And if it continues to be an issue, Dick, we can revisit it. Okay, great. Given our time frame, I'm going to move us along to Alan. You have the last rule, which happily gets rid of some COVID era. We're repealing some rules, right, that have become obsolete.
They will be obsolete. It's perhaps a moving target, but we've sent out for comment the termination of this rule relating to the housing assistance. They've closed to new applications, and they expect they'll have completed processing them in early in 2024. So once we get word that they've closed the program, then the committee will put that date in of when the rule expires. We've talked in the past about this it was in the context of the rental program, which is still in the last stages of closing out. But we don't want to be too premature, but we don't want to have a rule too long on the books that's obsolete, because it does cause confusion, as we've noted.
Right. Thank you. So our action on that is to say, I think, just thank you, and we will bid it adieu at the end of 24. When is the final end of that? 24, I think. Yeah. So I think our action is simply to say thank you at this point, right?
Right. No action other than comments, if any.
Right. Any comments? I don't see any further ones. I think our noted, Dick, on your comment about and concern about the mail, and I think we should just begin to keep our antenna up on that. Thank you, Alan, very much. Thank you for your work on all these rule updates. Much appreciated.
Yep.
Oh, you have two more? No, I thought you have two more. Oh, I'm so sorry. You have two more. I keep thinking that Tim has arrived in the room, so I keep thinking we're already ready for Tim. Great. Let's go to Rule 11 and then Rule 3 and 27. Is Alan?
Rule 11 looks pretty good.
I'm happy to cover them.
I'm sorry.
We're adding the telephone number.
I apologize.
Do you want, I mean,
Sure. We have 25 minutes, so I need to. I totally am sorry about that.
Alan, if you're not back, I'm happy to cover these.
Oh, I didn't see them on my, just the telephone rule?
Yeah. Rule 11A. You want to do it?
No, you go ahead, Emily, and I'll listen.
Any comments? All we're doing is adding a phone number here, right?
Yeah, so Rule 11A, this is the rule on what you need to include on the bottom of your pleading. It already requires you to put other kinds of contact information. And one of the feedback that was received is that if you're a self-represented party, if you're a lawyer, you have really easy access to the phone numbers of other lawyers. If you're a self-represented party, it's difficult sometimes for you to find a phone number to call a lawyer. And so this is a change that would require attorneys to, in addition to other kinds of contact information, provide a telephone number for contact.
I think this is good. Everybody's okay. I think we're in.
And then the final is 2 appellate rules. And these were at the instigation. They were suggestions that were made to the Civil Rules Committee that has kind of dual jurisdiction over the appellate rules with criminal. The first involves an appellee's docketing statement, which is, for those of you who don't do appellate practice, it's sort of an initial form that's filed with the Supreme Court that tells what the case is about. So the appellant is the person who's filed the appeal. They have to file one with the court. The appellee is the person that's responding. And in practice, the rule used to say that you must file one, but in practice, there was no adverse consequence for not filing one. And the suggestion was made to just make it optional in the rules so people don't think that it's something that they have to file. So that's what that proposal is doing, is making it an optional filing, not taking out that word must, but warning people that if they don't, that they might lose their chance to object to the things that were written in the appellant's docketing statement. And then the change in Rule 27 is allowing a reply in response to a motion. So someone makes a motion, the other person files a response, and then this would allow a further reply to that motion and setting a deadline, a timeline for the response to that motion.
Right. Any comments on this?
That's great.
Okay. Great.
Alan, anything you want to add?
Yeah, I'm sorry I didn't have this on my list, but yeah, on the last one, I've had 2 comments from the bar, both former Solicitor Generals, and in support of it. They say it lets other people know what the regular practice has been, so that it levels the playing field for self-represented litigants to know how the system works.
Right. Thank you. Well, then, thank you. Thank you, Alan. Thank you, Emily. And
you're welcome.
Judge Tomasi, you are on deck.
Okay, on deck.
Yeah, you're on deck. You can, yeah, Emily looked up that.
And you're already.
Right. So our last rule for the day, 16.
Well, it's actually a number of rules.
Yes, no, they're all under.
Good afternoon. Chair Clarkson and Vice Chair Rachelson, everybody in the committee. Nice to see you. I got the anchor leg. Got the anchor leg here. I'll try to go fast. We did do a number of, I'm the chair of the Public Access to Court Records Committee, and we did a fairly extensive review over the last months in a number of different areas. It'd be great to get your thoughts and considerations. We proposed a number of rule changes that went out and were promulgated in October. And then they're effective January 1st, 2024, absent hearing things from you folks, perhaps of putting the brakes on. So
Maybe you can introduce Patrick.
Yeah, I was about to do that. And we also have with us.
We have, my fault. I'm completely sorry.
We also have our intrepid reporter, Petra House, who is on the video.
She's right behind you. She's got your back.
She does, right there. So if I screw up anything, I'm hoping that Petra will help me out. So we went through a number of different proposals and changes and kind of vetted the rules and the exceptions and kind of came up with sort of a number of changes that probably were, some of them were overdue, some of them are pretty minor, but I'll just kind of go through them. If you want to talk about any specifically, I'm happy to slow down and do that as well. So first of all, we deleted a number of exemptions that were exceptions to public access that were either no longer really being used in any sense or were already covered by legislation that you folks had passed. And so we have an appendix now of things that are covered by legislation. So we've taken all the rules exceptions and just put them there where we don't want to do double coverage. We then streamlined to try to clarify the language to combine similar exceptions into one. So if you were looking to see whether an exception applied to you, you wouldn't have to look through them all. To look for financial information, for example, we put that all into one. For healthcare information, we put that all into one. Oh, so they're a little it's a little easier for people who are trying to figure out how to decipher what exemptions might apply.
Well, anything that makes things easier is good.
Let's hope. I think that was our viewpoint and try to.
Easier to decipher. That's our.
There are quite certainly a number of exceptions to the rules, and so the fewer the better in our sense. We changed the language to move from the word document and data element to record. That's, we have the state archivist is one of our members, and that's sort of a national term that's sort of more in vogue and more modern to use the word record instead of documents and things along those lines. We changed the language, another language change to say that documents now, the ones that you don't have access to are not publicly accessible as opposed to being non-public, because most of the documents actually are public documents.
Right.
They're still the people's records, but they may not have access to a particular one for a particular reason. So that's the phraseology that we've kind of turned to. On more substantive areas, we've clarified Rule 6B12, which has to do with search warrants. And there's a process in the regular criminal rules saying that search warrants are not open to the public until there's a return on it from the law enforcement officer. After that, if the state's attorney wishes to keep it sealed, there's a motion practice. So if there's an ongoing investigation, the state's attorney might ask for it to be sealed. And there's a number of Supreme Court cases that sort of lay out the common law of how you balance the First Amendment interests in that versus the needs of the investigation. And we clarified Rule 6B12 to make it clear that that rule applies for how you decide whether to keep a search warrant confidential, as opposed to, we have a separate rule, Rule 9 in the public access records, which in any other kind of situation, you might be able to make a motion in a case asking for this particular record to be sealed for a particular reason. There may be something in an individual case that might matter, but that has a different process, requires service on everybody, but that doesn't really fit for when you're trying to sort of do a search warrant and not let anybody else know about it. We also clarified Rule 6B16 exception, which talks about discovery materials. Most times in litigation, when one side gets discovery materials, those aren't open to the public just because they were produced in a court case. But if you admit one into a hearing or offer it to be admitted into a hearing, that document would be considered public at that time. And we clarified it to make it clear that it may not be the whole document. It's only the part that's actually offered into evidence that is now public. So if you had one page of a tax record that was admitted, it doesn't mean the whole tax record would necessarily come into would be a public record at that point. We had a number of judges and attorneys had raised the question. With the advent of the sort of remote hearings like we're doing here today, a lot of judges have asked that there be pre-filed exhibits. So like 3 or 4 days in advance, get the exhibits filed. And when that happens, they had been considered to be public records at that point. A number of attorneys felt as though that they didn't necessarily, and we did that just for administrative ease, so you don't have to have it scanned during the court proceeding. But a lot of lawyers felt, a number of lawyers petitioned us and asked that we change the rule to make it clear that, essentially they want to treat it almost like it would be in an in-person hearing. If you had your exhibits in your briefcase, they wouldn't actually be, and you might not choose to put them into evidence. Some of them might be embarrassing, and you might not decide to actually even ever offer them. So they felt like it was better to have that kind of a scenario. And so we kicked that around, talked to the number of the trial judges who tended to agree. And so we changed the rule to say that those are not publicly accessible until they're offered into evidence. So if they're offered into evidence, then they're publicly accessible, whether the court lets them in or not, that makes it a public record at that stage. Then lastly, the last major change was to Rule 5I. 5I has to do with all of Rule 5 essentially says, for litigants and lawyers and guardians, you have a special right of access. So even if the public in general might not have access to certain materials for your case, you would have access to it. It was written very broadly, though, and if you read it extremely broadly, you might come to the conclusion that the lawyers and litigants would have access to almost everything, including judicial work product, ex parte requests for relief, RFA orders before they were ever decided upon. So we had to kind of bend that back a little bit and make it clear that the specific right of access doesn't give you a greater right of access in those kinds of cases that are specifically delineated in the rule. So you don't get access to my work product or the law firm's work product and RFA filings, things along those lines.
Helpful, I would assume. So,
for sure.
Thank you. That was a lot under.
It was a lot.
All those. Comments. Committee must have some comments on these. Oh, I don't have to, but yes, Mark.
So I think, yeah, this does clarify things a lot. I thought this was great. But I do have, I don't think this will be elevated to an objection, but I don't know if you, at this stage, is too late to clarify something?
No. It becomes effective in, when did it?
January?
January 1st.
It becomes effective, yeah.
Well, let me just, so on page 5, subsection B, exceptions, I found that introductory paragraph confusing, and
Under case records?
yeah, well, the public does not have access to the following judicial branch case records, which had a colon, which would lead to the 1 through whatever, which, I mean, that's a minor point that when you get to B1, that's not really a sentence without that colon before. But put that aside. I found more of the exceptions to public access involve a type of case, a record information, or record and part of the information within it. I just didn't think, I mean, I didn't know what that meant. And I was wondering why instead the clarification that is in the reporter's note, that's on page 8, the third paragraph of the note, case types that are not publicly accessible by statute, specified records that are exempted from public access by statute or other law, and information within a case record that is exempted from public access. Why that language would be used there instead? Because then you know what they're talking about. When I just look at the exceptions to public access involving type of case, what does that even mean? Not critical. I mean, if I were to have written the exceptions, I would have led with the language that I just mentioned from that page 8, and then I would have had the second sentence be the public does not have access to the following judicial branch records, colon. Again, take it or leave it, but I think that'd be a lot clearer.
It certainly sounds clearer. I guess the type of case would have been sort of like a juvenile case, for example. I think that's the type of case.
No, I understand.
Right.
No, I understand.
Yeah, I take your point. It's kind of awkwardly phrased. And then the note is better.
Yeah, I mean, and I would lead with the note and then have that first sentence second, just that leads into the list a little more grammatically, I guess, is what I'm saying. But only a suggestion, not an objection.
Well, we'll see how they choose.
They reject this,
Well, then you'll object.
As Emily says, it's easier for us to do it at this point than it is.
Well, these have been promulgated, so
Yeah, the thing
we have to
that's-
promulgate an amendment to the.
So you decide.
To that.
We
But I
give
thought
it
I
to you
just-
as a suggestion.
Yes, that's all.
And even if we don't do it now, we could certainly potentially do it.
Yeah, it just was that introductory.
Yeah. No, it's very clunky. I agree. I think I agree with you.
Any other comments?
Otherwise, it was lovely.
Yeah, otherwise, good work. Thank you. Thank you very much.
Well, Petra did a lot of work as well, so especially her. So
Thank you, Kedra.
Thank you.
Are you a law clerk at the Supreme Court?
I'm actually a staff attorney.
Oh, yes.
Yeah.
Right. Lovely to see you.
Yes, you as well.
Is this your first time in our committee?
It is, yes.
Well, welcome. Don't be strange.
Well, I hope to be there in person at some point once we get our office back.
Well, Emily's here in person.
True.
We're kind of a fun day out if you come to the legislature to a field trip from your home, from remote offices. Committee, I think thank you. Thank you.
Thanks, Bishop.
Well done. And committee, nice work. I have no idea when we'll meet next, when we have another avalanche of rules to review and comment on and or say thank you.
Hopefully when they're proposed, so suggestions will be taken.
Yes, but we don't get into the regularized thing until 24. Well, 24 is weeks away now.
It's just weeks away now.
It's frightening. Okay, I'm not going to, I think all that has to go through. Dick, it's good to see you. Barbara, good to see you. Tom, good to see you briefly, in and out. Pedro, thank you. Alan and Tim, all great. Thank you, Emily. Thank you, Aaron.
Thank you.
And we will be interested in hearing about remote cases. I think our questions about that are going to evolve. And we're interested in also hearing if anything happens with any additional issues with the post office and, just sort of track audio appearances in our.
Ready to go offline?
I think we're ready to go off live. With that, I think we say thank you to everybody. And Dick, good to see you. And we shall
Hope
see
you're
each other
well,
soon.
Senator Sears.